Good morning or good afternoon, depending on where you are. My name is Rich Palma. I'm a partner at Thompson Hine in the New York office. I am in the business litigation group and work in the construction and international arbitration practices. And I would like to welcome you all here today to our webinar. Before we get started, there's a few housekeeping items I'd like to just bring up and get out of the way. Today's program is being recorded, and we will send a link to all attendees within 72 hours of today's presentation. If you have any questions during the webinar, feel free to use the questions box located on the control panel on the right side of the screen to submit questions. And you should submit those questions throughout the webinar, and we will get to them at the end and try to answer as many as we have, depending on how many there are. Lastly, we're offering a CLE credit for today's webinar. Be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You'll need a tracking code, which will be announced at the end of the program. In the handout panel, you can also download the PowerPoint presentation slides and the bios of our speakers today. So with that, let me move forward to introducing my colleagues that will be presenting today. Joining me today are my Thompson Hine colleague, Sean Gordon, partner in our business restructuring, creditors' rights, and bankruptcy practice group. Eric Heyer, a partner in our business litigation, e-cigarette and vaping industry, and government contracts practice. And Joe Smith is in our e-cigarettes and vaping industry. He's a business litigator, and he's also in our products group. I'll be starting us off today with a discussion about recent trends in the federal courts and civil litigation involving industry participants. So let's get started. So of course, the problem with enforcing contracts in the industry is the same one as we see in other areas of the cannabis industry, and that is that the production, distribution, sale, and possession of marijuana remains illegal at the moment under the Controlled Substances Act. There's an increased number of states that have legalized cannabis use, both medical and recreational. We've seen continued erosion of any consistent policy at the federal level. There have been some movements forward and some movements backwards, but generally you would expect that we are moving towards legalization. We are not there yet, and it remains illegal. I think the public, as a general matter in the US, has come to accept that marijuana use will be legalized at some level across the country. And all of these together, you would think would give you a prediction that federal courts would be more likely to enforce contracts involving the industry within disputes, private civil disputes. And that was the case a few years ago with a trend of cases moving in that direction. And as we will discuss today, there have been 3 cases in the last year that have put into question what the true policy is going to be among the federal courts. So the original case that is most often cited is Tracy versus USAA Casualty Insurance. This was a coverage case involving a woman in Hawaii who had a group of marijuana plants stolen from her property and put in a loss with respect to those plants to her insurance company. And the insurance company did not pay. And the court did an analysis, it did a coverage analysis, but in the end, the court found that it would not enforce the contract because the enforcement of the contract and causing the defendant to pay the plaintiff's claim for the loss of her medical marijuana plants would constitute an illegal act, and the court would not force an illegal act as a remedy, and found as a result that the defendant in not paying was not in breach of the contract. That was not a remarkable decision at the time, although some people wish that it had gone another way. But within a couple of years, the activities were in 2010. The case was decided in 2012. But by 2016, we had a trio of cases that where federal courts began to look differently at this. And Green Earth Wellness Center was the first. It was decided early in 2016. And this was another insurance coverage case. It was in Colorado. And the court in the District of Colorado explicitly refused to follow Tracy. And in doing so, it cited the continued erosion of federal policy and enforcement, and then looked at the case law around the enforceability of illegal contracts, and ultimately found that although it remains a criminal act under federal law, so long as the court was not enforcing an illegal activity by its remedy, it would enforce the contract. And it went a long way towards stating that that the insurance company knew what it was covering when it entered into the contract of insurance, and it should not be held to backtrack on its promise to pay for a loss. And so that was the first case. The standard was not particularly well set out, but later that same year, and my slides are a little out of order, so I have to jump to Mann. In the Northern District of California, the court laid out a standard that continues to be applied by the courts, even when they don't uphold a contract. But Mann involved a dispute between a buyer and a seller of two cannabis industry businesses. One was a consulting business, and the other was a retailer of growing equipment. So neither company, and this seems to have been important at the time, actually was involved in handling of the marijuana. And the court analyzed the case law with respect to illegality and looked at the federal policies with respect to marijuana use and state, and including California state law on the subject, and it did an analysis of when a contract within an illegal industry or an illegal actions could nonetheless be enforceable. And the court found ultimately, and this is the standard that has been applied in subsequent cases, that so long as the court can find a remedy that would not require it to order a violation of the law, and in this case, the CSA, it would permit the contract claim to go forward. And that is exactly what happened in Mann. Now, early in 2017, in the District of Texas, another case, Ginsburg v. ICC Holding, and this was a case seeking to enforce payment on notes related to loans to a cannabis company, and the payor raised the question of illegality, and the court did not see the payment on the notes as being an enforcement of a remedy that required illegal conduct. And so the court in Ginsburg likewise held that the claims could go forward. And so we get to 2017, and it appears as though the courts are moving in a fashion towards enforcement. When the case of Bart Street came up, Bart Street is another loan repayment case, not dissimilar to Mann. And the court agreed that certain contract provisions may be illegal and certain may be legally enforced. And so with respect to the contract claim, the court allowed that to go forward with the caveat that depending on how the case played out, it may or may not be enforceable if the illegal portions could be severed. However, with respect to the unjust enrichment claim, the court struck that claim because it said that in order to allow an investor to profit from the cultivation, possession, and sale of marijuana, it would have to permit an illegality. And the court raised illegality sua sponte. And in finding that that claim could not go forward, the court concluded that conspiracy to cultivate marijuana is a crime of moral turpitude, a phrase that has not been used too frequently recently, and caused me to throw this slide into the mix, just because I can't believe the court would go out to moral turpitude with respect to marijuana use, but there you have it. Later that same year, in Oregon, another, theoretically cannabis-friendly state, the court in Lilly raised illegality as well, and it cited Tracy, and it would not award plaintiff damages for lost profits because it said that it would require the court to compel defendants to violate the Controlled Substances Act. And then in a case that started out in 2020 and moved into just recently, the decision was in March of 21, a plaintiff was given 3 chances at the plate. In the first instance, Polk sued his business partner for a business in Washington state that involved the growing and distribution of marijuana. And because Polk himself had a criminal record, he could not be a party in interest under state law as one of the owners. And they tried to find a way around it. And he continued to work in the business and had an oral agreement with his partner, the defendant here, that he would still be in, and they tried to find ways to get a monetary interest to him without violating the law or using his brother as a purported investor, etc. But they could never agree. And so in the end, Polk decided he wanted to leave the business. He did not want to have the uncertainty of his ownership as the business continued to grow. And his partner raised illegality as a basis for saying in the lawsuit that he would not pay him his interest in the company. And so the court initially found that because Polk sought an equity interest in the entity, that it would necessarily involve a remedy that would contravene federal law, and dismissed the case but gave leave to replead. And so in the second round of this case, Polk deleted from his amended complaint the request for an equity interest in the company and sought only past and future profits from the business. The court again looked at it and determined that specifically with respect to future profits, that again had the same problem of providing revenue from a business that would be violating federal law, and dismissed the second complaint as well and gave Polk one last chance to replead. And he dropped the future profits claim and sought only the remedy of past profits. And the court again dismissed, this time in March of this year, March 22nd, the decision came down and basically said, in order to give him past profits in the business, you'd have to find or make him a party in interest as that's defined under state law. And because Polk could not be a party in interest, due to his record and because he was not vetted by the state government officials that are in charge of providing licenses, that he would not be allowed to get that remedy without violating state statute, in this case, not the federal statute, and found therefore that it would involve illegality and dismissed for the third time, this time with prejudice. And this case is a couple of months old. So we do have, a trend that looked favorable for enforcement between participants within the industry or between vendors and industry participants. And then a bit of a backtrack. Each case is a little unique, and the analysis does require a case-by-case approach. The Mann case and the analysis with respect to finding a remedy within an illegal contract that does not require the court to condone or award damages or otherwise relief that would cause an act of illegality still remains the analysis. But courts seem to find a way around that if they are inclined, even in favorable jurisdictions, to dismiss a claim. What I think the takeaways here are is, number one, in drafting your complaint, if you have to bring a complaint in while federal law still holds this activity illegal, you need to find a remedy that you can give to the court that you think will be accepted as a non-illegal remedy if you're going to have a chance to sustain a complaint prior to federal legalization. In addition, in drafting contracts between participants, you should be mindful of enforcement, and in particular, think about jurisdiction, choice of law, severability clauses with respect especially to remedies and things of that sort, and try to figure out a way to give your client the best chances of enforcement if they have to do it prior to the time when the industry becomes legal. One idea is to use arbitration, which is a private dispute resolution remedy. The problem will still be that if you are forced to go into court to enforce the award, you may still run into some of the same problems. But we'll see. I think you have a better shot there if you go and get an award and then move in state court for enforcement, if you can do that. And I do think that my prediction here is that we may see one of the associations, industry associations, create a self-regulated scheme for dispute resolution like we see in things like the securities industry, the commodities industry, to resolve disputes. The benefit there is that you would have neutrals that would have industry experience. They would understand how it works, presumably are favorable to enforcing contracts. Now that depends on what side of the V you are on, but that is something that you may want to have. And then you would have award enforcement. An association can strong arm its participants into complying with awards voluntarily as a condition to remaining in the association or other things. And so that's where we are at the moment. It continues to evolve. I don't know what the next steps are going to be, but we'll be back with another update at the time when somebody construes these last few cases. At this point, I'm going to turn this over to my partner, Sean Gordon, to bring you some updates on bankruptcy in the cannabis industry. Thank you.
Thank you very much, Rich, and good day, everyone. I'm Sean Gordon. I am a partner in the bankruptcy group here at Thompson Hine, based in Atlanta. I also occasionally work out of our firm's Cleveland office, and I've been practicing since 2001 in the insolvency space, and we handle a lot of creditors' rights matters, including lender work, Chapter 11 reorganizations, liquidations, receiverships, trustee representation. We do loan workouts, other litigation matters, both inside and outside of bankruptcy. I'm very pleased to be here today to talk to you about the intersection of cannabis and bankruptcy law. Basically, in a nutshell, bankruptcy and cannabis, similar to the lines of the themes that Rich was going over in the contract space, bankruptcy and cannabis do not mix well together as things stand. Under the current state of the law, it is very difficult, if not impossible, for a struggling cannabis business to avail themselves protection under the bankruptcy code. And it is an issue because unavailability of bankruptcy relief, it impacts not only companies that are in the business of selling marijuana products, but also their creditors, because the bankruptcy court is typically a forum for transparency in federal court and for creditors to receive a fair distribution on their claims under various circumstances. So just to give you a brief overview of what we're going to be going over today, we're going to discuss some selected noteworthy cases that have analyzed why cannabis-related businesses are not allowed to be in federal bankruptcy court. Then I'm going to talk about some alternatives to federal bankruptcy, such as assignment for the benefit of creditors, receiverships, and out-of-court workouts that debtors and creditors can look to for relief in this environment. Just to give you kind of the broad overview, since 2017, there's been a policy by the U.S. trustee who is responsible for overseeing the bankruptcy process to seek dismissal of a bankruptcy case if assets or income is derived from marijuana by the debtor. It really is an inconsistent policy, as there are many states legalizing cannabis, and at least as of last month, we counted 17 states in Washington, D.C. With legalized cannabis products. The U.S. Department of Justice has also been diverting resources away from these prosecutions for marijuana crimes, but the federal law is what it is, and if a debtor is seeking relief under the bankruptcy code, under federal law, while continuing to commit a federal crime under the Controlled Substances Act, the debtor is going to face some problems. We're going to start by talking about some of the cases that are sort of the low-hanging fruit that have a direct relationship to cannabis, and these go back pretty far, going back to 2012. One of the seminal cases on this is the rent right case. In this particular case, coming out of Colorado, the bankruptcy court there, the debtor had 25% of its income from leasing warehouse space to tenants who grew marijuana. The court ended up dismissing the case under 1124 B4B, citing gross mismanagement of the estate and a bad faith bankruptcy filing. A few years later, in the Johnson case, in the individual context, this was an individual Chapter 13 case where the debtor got half of its income from growing and selling marijuana, and the bankruptcy court held that this was patently incompatible with a bankruptcy proceeding and enjoined him from continuing that business while he was in bankruptcy. Moving on to the Way to Grow case, as we fast forward to 2018 in Colorado, you start to see bankruptcy courts facing issues where it's a little bit more attenuated. In the Way to Grow case, the debtor sold marijuana-related growing equipment and supplies to other businesses that sold marijuana, but not marijuana itself. And in that case, the secured creditor moved to dismiss the case. That motion was granted. The court found that the case could not continue because the debtor was complicit in a federal crime, and dismissal was required where a trustee or a debtor in possession is required to process and administer assets that are illegal under the Controlled Substances Act or even constitute proceeds of an illegal activity. Later on in Michigan, the bankruptcy court there out of the Eastern District in the Basra case, again, debtor leased a portion of its real estate to a company that operated as a medical marijuana dispensary, which is legal under state law. The debtor wanted to use the bankruptcy process to simply reject the lease and enter into a new one for the same type of business. That case was also dismissed on grounds that the debtor had unclean hands and didn't untangle itself with the pot-related business that violated the CSA. Interesting case here coming out of the Ninth Circuit, and this is the only case that I'm aware of that has not gotten dismissed based on a connection to marijuana business, really under a procedural loophole. In the Garvin case, from 2019 in the Ninth Circuit, who's known for some cases that can sometimes be a little bit on the fringe. In this particular case, the debtor was a landlord who leased property to a business that grew marijuana. The case was not dismissed outright despite motion by the U.S. trustee, and the debtor had actually proposed a plan to reorganize that got confirmed ultimately. The Ninth Circuit in that case held that the trustee's motion to dismiss, which was initially denied without prejudice to refile, was waived simply because the trustee failed to renew the motion at the appropriate point at a later point in the proceeding. So even though the debtor was connected to a marijuana-related business, the court nevertheless ruled that the debtor's plan was perfectly fine under Chapter 11, and it didn't matter that it violated federal law. It only had to comply with the relevant Chapter 11 provisions for plan confirmation. I really see this case as an outlier. Without that particular waiver, I think that case would have been dismissed, and it really was just a procedural loophole that permitted the debtor to survive in that one particular case. And as you'll see as we go forward in later cases, including within the Ninth Circuit, this policy starts to get really expanded. Any tangential relation to the marijuana industry usually ends up in dismissal. We start with moving forward to 2020 in the Burton case, also coming out of the Ninth Circuit from the Bankruptcy Appellate Panel there. It's another individual Chapter 13 case, and in this case, the debtor owned a majority of a cannabis business, and the U.S. trustee, consistent with its policy, sought dismissal of the case. The debtor responded that the company at issue was actually defunct, not being used to fund the debtor's proposed plan. But even still, the potential recovery from former business activities connected to cannabis was enough to require dismissal because risk that the Chapter 13 trustee would have to administer assets in that bankruptcy estate that were derived from illegal activity. The Malul case coming out of Colorado, also in 2020, this was another individual case demonstrating how attenuated things can get when it comes to dismissal of bankruptcy cases and marijuana. In that case, the court refused to reopen the case that had been previously closed, where previously undisclosed assets and claims were related to marijuana activity. It didn't even matter in that case that the Chapter 7 trustee wanted to help the debtor reopen the case and was all for it, but the court nevertheless refused because prosecution of her litigation claims by her or the trustee would constitute an ongoing violation of the Controlled Substances Act. One of the more recent cases that we're going to talk about today, the Pharmagreen case, this one's really interesting. I mean, when you talk about pot adjacent companies, in this particular case, which this decision came down in October of last year, the debtor had not previously engaged in marijuana business at all, but simply intended to get a license in Canada to engage in cannabis-related activities and business. The court dismissed that case on various creditors' motions simply because the debtor's proposed business model in the case was in violation of federal law. So you can see how that policy develops over time. Anything that touches or is related to, even tangentially to the marijuana industry, has a very difficult time staying in federal bankruptcy court. So what is a creditor or a marijuana business to do? Well, there are some alternatives, and some of them can be very good alternatives. I think that there is a reason why many companies go into the federal bankruptcy system when they need insolvency relief, and that's because the court really has nationwide jurisdiction with the automatic stay that can stay activities all over the place. That can be a little bit more difficult in the context of state court. But some of the state court remedies that are available, or state remedies rather, assignment for the benefit of creditors, and then you have receivership, and then you can always do an out-of-court workout of your debt. So we'll talk about some of those now. With respect to assignment for the benefit of creditors, very similar to, in result, to a Chapter 7 bankruptcy case or a Chapter 11 case where a debtor is simply liquidating. An assignment for the benefit of creditors takes all the assets and they are assigned to a third party who will orderly wind down the company's affairs and liquidate the company. This is a creature of state law, and it is very widely used. As of summer of last year, we counted 38 states in the District of Columbia that have ABC statutes, and there are other states that have mechanisms under common law. This can oftentimes be a valuable tool that's cheap. It doesn't involve as much motion practice and court proceedings at all. And it can be an alternative for a business who is operating in a manner that's consistent with state law in the marijuana context, even though you may not be able to get into federal bankruptcy court. Receivership, state court law proceeding, often used. It can be a very powerful tool for creditors to put their debtor into receivership. State court can appoint a receiver who serves similar to a trustee in bankruptcy to oversee the company during distressed times. Unlike an assignment for the benefit of creditors that involves liquidation of the company's assets, the receiver usually has broad authority to operate the company and keep employees on the roll. Some of the benefits, you can often get a much higher return for a company as an ongoing concern, and that's a huge benefit for a receivership. There are distinctions among the states in the various requirements, and interestingly enough, in the cannabis space, as of summer of last year, several states, which include the ones that are listed here, have passed laws related to cannabis receiverships. Some things to be a little bit careful about in those. For example, in Colorado, there can be requirements that the receiver itself must be licensed to deal in cannabis products. So there are some requirements that may need to be considered if this alternative is going to be utilized. Oftentimes, with respect to receivership, just a practice pointer, if you're representing a lender, you can include favorable provisions in your loan documents or forbearance agreement or whatever contract you are working on that has the borrower in advance consent to the appointment of receiver, and usually these provisions can be enforceable in most states. In terms of workouts, just the negotiation of the debt. Sometimes it can involve just two parties, the debtor and a lender. Other times you can do a composition agreement, which involves many creditors trying to get to the same result that a fair bankruptcy proceeding would provide, meaning pro rata share payments from whatever assets are available, so not one creditor gets preferred over the other, and that the creditor's priority in liens are respected. And this, even while bankruptcy may not be an option in the cannabis space, sometimes if you're dealing with a workout, you would still look to, well, what would happen in a bankruptcy as a useful starting point to begin those negotiations. So with that, I conclude my section on bankruptcy and cannabis, and I'm pleased to pass the baton here to my good friends and colleagues, Eric Heyer and Joe Smith, to discuss the PACT Act and other recent developments. Thank you very much.
Hi, everybody. My name is Joe Smith. I'm an associate in the Washington, D.C. office, along with Eric Heyer, who's a partner in our office. We work primarily in business litigation, but also largely in the vaping industry. And one issue that's come up quite a bit over these last several months that we're going to talk about is the PACT Act, with Eric working largely with nicotine companies that are involved in vaping and who are affected by this, and me working with a number of clients in the cannabis and non-nicotine space, especially CBD and more and more Delta-8 products who are affected by the PACT Act. And so we're going to talk about what the PACT Act is and how it impacts those companies. So yeah, so the PACT Act was put into the end of year COVID relief bill. And what it is, it's the it's part of the Preventing Online Sales of E-Cigarettes to Children Act, and essentially it subjects electronic nicotine delivery systems, so e-cigarettes and similar devices, to the Jenkins Act and Prevent All Cigarette Trafficking Act, the PACT Act. Both the Jenkins and the PACT Act have been on the books for years, focusing on traditional tobacco companies, cigarette companies, roll your own cigarette companies, other tobacco companies have been affected by this for years. And as part of this expansion, the legislation defines ends broadly enough to apply to cannabis and cannabis-related ends products. And that's because, as you see there, the definition is written such that any electronic device that through an aerosolized solution delivers nicotine, flavor, or any other substance to the user inhaling from the device. So the key phrase there is any other substance, which brings in cannabis, CBD, marijuana, Delta-8 hemp products, and a variety of other non-nicotine products into the scope of the PACT Act if they can be used with an ENDS device that are subject to the PACT Act. And so if you're familiar with the cannabis industry at all, whether it's marijuana for medicinal or recreational purposes, or CBD or hemp oil, an increasing way of using these products is through vaping. There's been a growing shift from, I'm sure everyone's seen the gummies and things like that. And obviously we all have in our mind of if people go into a dispensary in the states where marijuana has been legalized, they're seeing all these plants. But the reality is while that still is the case, there's also been a growing amount of use of ENDS devices to use these products. And so the expansion of the PACT Act, especially for those in these industries, creates quite a challenge because they're not used to it. In most of these states, CBD really isn't regulated. In the states where marijuana is legalized, whether for medicinal or adult use, they have their own separate framework. So this is a whole new bag for them of what they're trying to deal with. And so the first part of the PACT Act requires interstate sellers and shippers of ENDS products to register with the ATF. That's the first step, which, to be honest, isn't that big of a challenge. It's a short form. You just have to include information about where you're shipping and selling to, information about registered agents. Where the real challenge comes in is it also subjects interstate sellers and shippers potentially to licensure, taxation requirements, as well as registration and reporting in states into which they ship or sell. If those states have a tax on cigarettes, because you see, one of the problems with the legislation is rather than having ENDS as a separate category, they tucked it within the term cigarettes. Well, as most people know, most, if not all states, have some kind of tax on cigarettes. The problem with that, though, is not all states have taxes on vapor products or ENDS devices. And even those that do, their definitions and terms vary. And so some states only tax the liquid itself. Other states tax the liquid and closed system hardware, such as like your Juul device, and others tax anything and everything under the sun relating to vaping. And there's about a little over 30, and there's a couple more states who are adding in the near future, will be adding taxes. But even with that, that's further complicated because of those 30 or so jurisdictions that tax ENDS products and other vapor products, only about 15 have a tax that could arguably apply to cannabis products. And that again is not because these states are specifically saying cannabis or hemp or Delta-8 or CBD are subject or within these terms. It's because they use, again, phrases like any other substance or any substance regardless of nicotine content. And so that's where it brings in these non-nicotine cannabis products and subjects them to potential licensure and taxation. And these requirements, now for wholesalers or business sellers, some of the requirements may not be as onerous because some of the states have, obviously their requirements vary. The bigger challenge is for the delivery sellers, which are those companies that are selling essentially direct to consumer. The ones online that if you went on and you were ordering a CBD vape cartridge or CBD solution or an ENDS device to be used with those, and they ship it to your home, you'd be considered, if that company did that, they'd be considered a delivery seller. And they're required to comply with all laws as if the delivery sales occurred entirely within the specific state. So where some states may say an out-of-state wholesaler doesn't need a license, or they don't need a license if they only ship to other wholesalers, or various little ways to potentially not require a license, for that delivery seller, they have to act as if they had a storefront in that state and kept comply with all the same regulations. And obviously this creates some issues because in a lot of these states, they weren't planning on CBD or marijuana or hemp or anything like that being included necessarily within these definitions when they first enacted these statutes. So it creates this weird situation where non-tobacco companies are having to seek things like a tobacco license or pay a tobacco tax, what the state may view as a tobacco products tax. And so those are the initial requirements that are kind of put on. And again, with that, these companies not only have to register with the ATF, they also have to register with each of these states and then report every month all the ENDS products they're shipping or selling into those jurisdictions. So this creates an ongoing burden for them, even in the states that don't necessarily tax their particular product. And then additionally with that, anything they ship into consumers, there are a variety of labeling requirements, saying that it's basically making clear that it's a tobacco product that is covered by the PACT Act, which again creates this weird situation for cannabis and non-nicotine companies to have to put on that they're shipping a tobacco product, when if you ask them what's the tobacco content, it's zero. There's no tobacco, there's no nicotine in these products. But yeah, so this has created a whole lot of headaches, to be frank, for these companies, because for many of them, they're not used to it. And also, they look at it and say, well, I'm subject to all these other potential regulations and restrictions, but now I've got to add in this tobacco that's never applied before. And I don't, and some will say they don't think they're intended and they'll waiver. But the reality is under the statute and the way it's written, and we can have a long argument about whether it could be drafted better, non-nicotine cannabis and hemp companies are covered by if they sell ENDS product. And penalties for knowing violations for delivery sellers can include potential criminal charges. So it's not just potentially getting hit with a fine, which I've laid out there. Civil fines can be $5,000 for the first violation, $10,000 for each subsequent violation, or even 2% of gross sales, which can add up to a significant amount of money, depending on how a particular state wants to say, oh, this is a violation, or the federal government wants to say it's a violation, but also those criminal charges. And on top of that, you could be, non-compliant companies, especially if it's a knowing violation and not just I don't want to say negligence, but an inadvertent violation. You can also be facing significant state penalties as well, whether it's civil or criminal, depending on how the state's licensing and taxation schemes are set up. So there's real consequences for non-compliance, and it is a difficult thing for these companies to navigate. But I know we're working with a number of companies and helping educate them on what they need to do, and also to some extent helping them actually get through this process. So that's the PACT Act as an overview. And now Eric is going to talk more about the USPS postal ban and everything that's involved with that.
And unmute myself. There we go. Thank you, Joe. Yeah, I'm going to talk about sort of the other side of the coin with respect to the PACT Act. But before I do that, I wanted to just go back to one point Joe made about the definition under this new legislation that passed right after Christmas last year of how electronic nicotine delivery systems are defined. In addition to having a substance, it has to have a solution to fall within the federal definition. And I think based on that there's a very strong argument that vaporizers, and the definition does include components or parts. So even if you don't have a complete kit or something that's pre-filled, if it's marketed for or labeled for use with something that fits within the definition, i.e. a solution that gets heated and aerosolized, then even the hardware, so to speak, the components or parts or the open system kit would fall within the definition as well. But one point I wanted to make is because the word solution is found in the definition, I think there's a very strong argument that vaporizers that are marketed and labeled as intended for use with waxes and dry herbs arguably fall outside of that definition. And that sort of segues to the part I was going to speak about, which is the U.S. Postal Service and the restrictions that the new legislation imposes there. So for over 10 years now, U.S. Postal Service has not carried in consumer mailings cigarettes and smokeless tobacco. And there's been a specific type of application and mother may I process to go that an applicant has to go through to be able to use the U.S. mail to send a business-to-business mailing of cigarettes and smokeless tobacco, called the business purpose exception. What the new legislation did is this expanded these requirements and these restrictions on mailing through the USPS to products that fit under that ENDS definition that Joe just talked about. And so it does include CBD products and Delta 8 products potentially that are vaped. And the restrictions on, there's an outright prohibition on B2C mailings, i.e. mailings to consumers. And then there is this process of getting a pre-clearance or application process under the so-called business purpose exceptions for business-to-business mailings as well. Now, under the legislation that passed right after Christmas, Congress gave the U.S. Postal Service 120 days to finalize a federal rule. And what it really is, it's a little bit different. It's not going to be part of the Code of Federal Regulations like many federal agency rules are, but it's actually a set of revisions to a USPS publication called Publication 52 to extend these restrictions on mailing over these federally defined electronic nicotine delivery system products. USPS's deadline to do that, as we say here in the slide, was April 26, 2021. USPS failed to meet that deadline, I think in large part because, frankly, this is one of those pieces of legislation that I don't think Congress fully understood what it was doing, whether it's with respect to the nicotine products or whether it was with respect to cannabis-derived products, because part of the business purpose exception application process would effectively have USPS going through an applicant's application and determining whether the businesses to which the applicant would like to mail the covered products are in fact compliant with the legal requirements to be legally operating in their jurisdiction. So it means potentially USPS is going to be an arbiter of whether a specific business has the state licenses that it needs and the state permits, potentially local business licenses, et cetera, for the types of products that the applicant indicates that they want to send under the business purpose exception through the mail. And so we don't know when this final rule is going to come out, but it certainly will. And we've been working with a large number of clients for several months now on all things PACT Act related, both, as Joe said, on the nicotine side and on the CBD or other cannabis-derived products side as well. And what we're finding is, whenever this is finalized, the business to consumer mailings will be cut off immediately. The business to business mailings, there'll be some sort of a blackout period because companies cannot even submit an application for this business purpose exception until the final rule is published and USPS sets up a mechanism for this to happen. And so what we're finding is a lot of wholesalers and distributors have really been scrambling to try and find and set up alternative networks. If you have palletized product that can go on a motor carrier, on a semi-truck, it's not as big of an issue. But if you have small packages that you're sending out to a particular, a vape shop or, some other business where it's not, a big enough volume to be palletized, it's a real difficulty because simultaneously with this, and whether it's considered to be bad luck or there was some plan here, UPS and FedEx have also indicated that they're no longer going to, as basically as company policy, allow shipments of vaping products as well. And those restrictions took effect back in early March and then I think in early April for FedEx and UPS respectively. And so that's left a lot of companies feeling a bit up a creek without a paddle. Now, fortunately, the delay by USPS in finalizing this rule, I think, is giving time for alternative networks to get set up. But everyone is now on pins and needles waiting to see what the final rule looks like. And USPS has provided very limited guidance on even what needs to be included in these applications. So it's very difficult for companies to even prepare them in advance and have them ready to go and submit the day the rule hits. So there is going to be some bit of a blackout period necessarily, I think, for those businesses that are trying to ship small packages business to business, and we're currently rely on USPS or plan to rely on USPS in the future for vaping products, including the cannabis and Delta 8 type products. So that's been sort of the other shoe that has dropped with respect to CBD and Delta 8 type products that are delivered through the vaping method of delivery. So the entirety of all this new legislation has posed quite a challenge, but it's been it's been very interesting for us to be able to advise clients on the best way to be to get their companies in compliance, and that's what we've been up to. So that's what that's an overview on that. We're close to ending a little bit early, but I think before we do, we'll see if we have any questions. I'm going to check, and then I'll give the CLE code at the very end here. Trying to see if we have any questions. There are some questions about not being able to download the handouts, or that the handouts will not open. So I'm going to ask our tech person that's dealing with that to see if we can get that resolved. Otherwise, I think when you signed up, if we have your email address, we can make sure that those get emailed out. I'm not sure on the technical side exactly what the correct answer is to that, but I would say try it again here in another 5 or so minutes. I know that I have a question actually for Sean related to the and if anyone else has any questions, feel free to please put them in the questions box on the right. But Sean, I have a question for you about the unavailability of bankruptcy and the cannabis business and marijuana businesses. Do you have any thoughts on how closely related or attenuated the relationship between the debtor and the marijuana business can or should be in terms of ability to avail themselves of the bankruptcy process? I mean, if they're supplying equipment, or if they're and does it have to be related to growing, or can it be something else? I'm curious as to your thoughts on where is that dividing line, right?
I mean, it's a great question, Eric. And from everything that I've seen going forward, it's really gotten to the point where any tangential connection to the marijuana industry, or even as that one last case, I think it was the Pharma Green case that we discussed, even if the debtor has never even engaged in the business of marijuana but plans to, can prevent that can cause serious problems with being able to retain the remedies in federal bankruptcy court. So right now, as the law stands, unless Congress acts and the Department of Justice changes its policy, it is a very difficult road for a marijuana-based business, or for creditors that are either landlords that are leasing space or providing equipment to a marijuana-based business. It can be very difficult for them to avail themselves of that protection.
Okay. Great. Does anyone else have any other questions? I'm not seeing our box be populated here, so. Oh, we do have a question. Let me see if I can get it open here. Trying to see if I'm reading the whole thing. THC, any updates on thoughts here? I'm not sure.
I think that may be connected to the one above it, and apologies. Oh, okay. This question ones are hard to read. It looks like questions about some states are unregulated for Delta 8 THC. Any updates, and I assume, or thoughts here? I could tell you this has actually come up recently with a couple of clients, because what we're running into, what companies are running into is, as you note in your question, a lot of states don't have any current regulations on Delta 8. In part because no one really counted or expected Delta 8 to really pop up and become as prominent as it has over the last year. But what we're seeing is, the federal government has started indicate that because there's a question of whether Delta 8 is synthetic rather than directly or naturally derived from CBD, that one, it should be considered a controlled substance. But there's pushback on that because there are a lot of people who argue that because it's derived from hemp, it's covered by the 2018 Farm Bill, and therefore it's legal, just as the same argument that's made about CBD and other non-Delta 9 THC products. But what we're starting to see more and more is more states, such as Kentucky, and I think there's about 10 other now that we're up to, saying Delta 8 is illegal. And that's not based necessarily on any new statute or legislation or rule being passed or implemented, but rather their state attorney generals or local law enforcement, which is really where it seems to be picking up, especially in some southern states. Local law enforcement is starting to crack down on it. And their argument is based on, under our existing prohibition on Delta 9 THC products or THC in general, Delta 8 falls within that. And the idea being that, well, we legalized certain products, but not all, but we still left THC, in this kind of illegal framework or position, and therefore Delta 8 THC, even though it's not Delta 9, it's still illegal. And so we're seeing more and more states start to pick that up and say, yeah, that's going to be our interpretation too. Now, again, that varies based on what their state law says, but we're not seeing quite as much of the new laws being passed. Now, there are a couple of states, I believe Oregon's one, and I think maybe Illinois might be the other, that are looking at potential actual legislation to clarify the position on Delta 8. But again, this is something that is, for a lot of these states and jurisdictions, it's relatively new. And like most of this stuff, it's not something people planned on coming from the 2018 Farm Bill. They weren't expecting people to start selling Delta 8 and say, well, it provides some of the similar effects of Delta 9, but it's not Delta 9. It's not as strong. It doesn't fit that category. It's clear, it's not clearly controlled substance. And so obviously it's kind of, to an extent, it has exploded. I mean, it is increasingly common, and a lot of companies are getting into it because just like they did with CBD, it's where the money is, and it's in an area that's, it's a very gray area right now is regulation. So, but I would expect there to be more regulation on that front as more jurisdictions get familiar with it. Until that time, it's going to be a lot of the kind of one-off local law enforcement that decide, hey, we think this might be illegal, take action. But I do think we're going to see more states taking action to either regulate it or just explicitly say it's prohibited, because obviously right now, with it being pretty much completely unregulated law jurisdictions, it's the same issue we run into with some CBD, where people can't necessarily trust what they're buying. They can't count on necessarily that it even falls within the definition of a allowed product under the Farm Bill, because the THC levels aren't necessarily clearly monitored in a number of labs, and I believe it was the U.S. Hemp Association's lab as well. And don't hold me to that. There's a major lab that basically said, we're not going to do testing for Delta 8 because we don't want it to be used to say it's legal or authorized, because it's in such a gray area. So I apologize for going on quite a ways there, but it really is just such a gray and complicated area right now for Delta 8 that it's almost, it's much like CBD was a couple years ago, where on an almost daily or weekly basis, there's some new update or change going on in the arena, in the legal arena for Delta 8.
And one related point I just want to make, and then we're going to have to wrap up here, but one of the things we're starting to see as well, even on the CBD and hemp front, is we're starting to see states impose licensure requirements. And Joe talked a little bit about sort of the tobacco licenses and how that can fit in for vaped products, but we're starting to see states enact legislation requiring licenses, no matter what form the CBD is in, vaped or tincture or what have you, that are requiring that, especially for what they call remote sellers or online retailers of those products as well. Louisiana is one state that has that. I think there may be additional ones out there and more on the way and pending legislation. So very much the CBD area, the cannabis area, very highly evolving at the state level, certainly at this point. So I think I don't see any other questions in the box, and we're about to our hour now. So I'm going to relay the CLE code. It's Cannabis 5 period 20520, Cannabis 5 period 20. And with that, I'll thank you for joining us today, and we'll make sure that I think the supporting documents, if you had any trouble downloading them, we'll try and get those, have our team get those emailed out in terms of the handouts so that everyone has access to those. And I think all of our contact information is there if you have any further questions. Again, thank you so much for joining us.